Hello and welcome everyone to the next in our Know Your Rights series. Tonight we've got a panel to talk about domestic violence. My name is Sarah McKenna. I am here on behalf of the Louisville Bar Association Public Service Committee. I'm going to introduce Michelle Duncan, who's also going to be co-moderating with me. Michelle.
Good evening, everyone. As Sarah said, Michelle Duncan. I am attending and appearing on behalf of the Charles W. Anderson Jr. Bar Association, formerly known as the Louisville Black Lawyers Association. This is, I don't know, Sarah, maybe 4 or 5 in our Know Your Rights series. So we're excited about our panelists tonight.
Next, I'd like to ask our panelists to introduce themselves. I always find it's more influential if you all tell us about yourselves and what you do than us try to read a bio about you. That can be sort of stagnant. So Ms. Gilbert, let's start with you. Tell us a little bit about your role and what perspective you bring to this topic.
My name is Dorislee Gilbert, and I am the Executive Director at the Mary Byron Project. We're a nonprofit organization that's dedicated to enhancing justice to end intimate partner violence. Mary Byron was a Louisville resident who was brutally murdered by her ex-boyfriend more than 25 years ago, and our organization was established a few years later, and in her honor, we have worked tirelessly for years in efforts to try to educate and end intimate partner violence. Before I joined the Mary Byron Project about 2 years ago, I was a prosecutor in Louisville for about 15 years. My work with victims and survivors of intimate partner violence began almost 20 years ago when I was a young prosecutor in the domestic violence unit at the Commonwealth Attorney's Office.
Thank you so much. Ms. Robinson-Kinney.
Hi, I'm Ms. Robinson-Kinney. I am the Senior Attorney of the Personal Safety Unit at the Legal Aid Society, and we serve victims who live in poverty in a number of different ways, but primarily through obtaining protective orders, civil protective orders, and a smattering here and there of divorce and other civil family law matters. And I'm really pleased to be here today. Thank you for inviting me, and I look forward to everyone's questions.
Thank you so much. Mr. Tibbs.
My name is Krsna Tibbs. I am a solo practitioner who practices mostly in criminal defense and family law. I've been doing this for about 6 years. Prior to doing as a solo attorney, I was a public defender in the Louisville Metro Public Defender's Office as one of the chief supervisors in the adult division. I did that from about 2004 to 2015. And while in private practice, I'm also a parent's attorney on the DNA docket for Judge Denise Brown, working on CPS cases and defending parents. I'm also a part-time public defender over in Clark County, Indiana, on cases involving in Division Circuit 2.
Great, thank you so much. And last but not least, Ms. White.
I'm used to it. If we were going in alphabetical order, I'd be last anyway. So I am Erin White. I am the currently the head of the Special Victims Unit, formerly known as the Domestic Violence Unit at the Jefferson County Attorney's Office. So our division prosecutes cases, as the name suggests, with special victims. So it's intimate partner violence, domestic violence as it relates to some family members, parent and children, and then also child abuse and sexual assault. So we handle all of those cases. If they're misdemeanors, they stay in our office. If they're felonies, they potentially go up to the Commonwealth's Attorney's Office. Before I moved to the County Attorney's Office, I also worked at the Jefferson County Commonwealth Attorney's Office. Dorislee and I worked together in the Domestic Violence Unit, and I was very fortunate to learn a lot of wonderful skills from her. She is a gift. And actually, Mr. Tibbs and I had our first trials together about 100 years ago. Our very first trial each was together. So it's really great to be here with all of you. Before I went to law school, I was actually a social worker, and I was drawn to the law to help victims that I didn't feel like I could successfully help when I was a social worker. So I feel like all of my professional life has led me, to this area of work. So I'm thrilled to be here and hope we can get some good information out for folks.
Thank you so much, Ms. White. Ms. Kinney, I want to start with you and kind of set a framework or foundation for what we're going to be talking about today, because I think sometimes we use language and we might all have different definitions for what we're talking about. So I want to start with, how domestic violence or intimate partner violence is defined legally in Kentucky, and if there's specific acts that are covered or not covered, and what that looks like.
Sorry, I remuted myself. So I'm glad that you asked the question that way. That's really interesting. In the sort of domestic violence community, like where we have the Center for Women and Families and some other organizations that work on things, I've noticed in the past few years that folks are starting to use the term intimate partner violence that sometimes is a little bit more accurate for romantic partner violence. But it is interesting because Kentucky law looks at it both from that perspective, which I think is more familiar in like a social context. I think people are more familiar with romantic partner situations, but there is also, as I think Erin mentioned, dynamics of violence between different family members, parents and children, grandparents and grandchildren, that sort of thing. And Kentucky law covers all of those types of relationships, whether you're just dating, whether this person is your child. A lot of those relationships are covered by the law. And domestic violence can look a lot of different ways. It can mean physical injury, serious physical injury, sexual abuse, stalking, strangulation, assault, or even the threat of those things. That can all qualify as domestic violence. And this can manifest really differently in different relationships. And I think the law does a pretty good job of being fairly broad and including a lot of different acts that could qualify as domestic violence and abuse.
One of the things that you mentioned there was the threat of a violence. So are there protections for verbal, as you mentioned, often when we think about domestic violence, we think about the physical acts of domestic violence, right? A woman who shows up battered and bruised. But I think we know that verbal abuse is a real thing and there's a lot of it. Is that something that there are protections for under the law?
That is a wonderful question because the way that the statute is written, not really, but the way that the case law has played out, I think that even though the law is written to be a little bit more narrow to kind of think about threats of violence or actual violence or injuries inflicted as a result of violence, we know it's more complicated than that. We know that there is an emotional element, there is a verbal element. And while that may not be particularly pointed out in the statute as something that you could base your protective order claim on, the case law kind of anticipates that that's part of the picture. So if you are going forward with one of these claims, that information, whether there's emotional abuse or verbal abuse, is absolutely relevant. And we actually have some cases that support judges looking at power and control dynamics and looking at lethality factors to determine if a protective order is necessary. So I think sometimes people may think, because I haven't received an injury from this person, I don't qualify for this type of order. And to that, I would say, that is almost certainly not true. If you look at the full context of what's going on in these relationships, if it looks in the full picture, like there's a power and control sort of element to this relationship, it probably does qualify for protection, even if it doesn't quite look that way just on the face of the law.
Is this the part where we jump in? And so, because like I said, I'm probably the defensive perspective on here. So, like Erin and Dorislee, and I had cases with Beth over family court. This is a big point of contention that we have on the defense side, because the law doesn't really, yes, the statute doesn't really cover verbal abuse, but it depends on what judge you're in front of, especially in family court. I just had a case where we had harassment, and I had a judge say, Mr. Tibbs, I think your client is done nothing more but than harass this person, and for that reason, I'm issuing a protective order. And not a protective order, a domestic violence order. And when you try to point out, well, this is, there's no physical threat made here. There's no threat of abuse or anything of that nature, but the fact that a person has said things to them that is vile or, harassing or verbal abuse, that can qualify for domestic violence order, which puts you under the same umbrella as a person who has stalked or assaulted someone or has done something else, which now limits your rights, your freedom, your access to weapons, and also goes on your record. And so, yeah, I have a big problem with that. And I think most people on my side, on the criminal defense side, has a problem with it, because you have to explain to people, well, the law doesn't claim allows for this, but it may be because it's subjective. Judges who pass out EPOs like candy and DVOs like candy, this is a way that they can do
it. Thank you for adding that in. I appreciate it.
Yeah. May I respond?
I knew I was gonna raise some eyebrows and get some retorts from that side. That was the whole point of that.
I see both Ms. Gilbert and Ms. White. Let's start with Ms. White, and then Ms. Gilbert, you can go next.
Thank you. I just want to point out, I think, and this will come up a lot, I think, throughout the course of this discussion, is that there are sort of two different worlds we're talking about that overlap greatly. There is the civil, often family court matter of protective orders, be they temporary or more permanent. And then there are the criminal charges. Often the same behavior is discussed in both courtrooms, but there are different outcomes and they have different impact on what happens. And Beth was talking about the specific statutes that allow for judges to issue emergency protective orders or interpersonal protective orders, but a lot of words can be crimes too. Krsna referenced the harassment. I'm sorry, my dog's going to make appearances occasionally. Harassment is a crime under the KRS in Kentucky. Terroristic threatening is a crime in Kentucky. And so words can be very dangerous and very violent, and they, I think, often portend what is also going on or what could go on. So I think it's incredibly important that judges take into consideration the totality of the circumstances. Someone who is willing to, threaten someone's life, threaten someone's loved one's lives, threaten the lives of, your children, your parents, your friends, that is someone who is potentially at risk for doing more violent behavior, or maybe has done more violent behavior, and they know the power of those threats. Likewise, harassment is a big part of stalking, and there are protective orders that are permitted for stalking. And so those constant phone calls, the text messages, the emails, the inappropriate contact when it's been made clear, abundantly clear that it is not welcome, that can rise to the level of criminal culpability. So certainly it should be considered for civil culpability. So that would be, I'll defer to Dorislee now. Thank you.
Thanks, Erin. That was great. I wanted to add, you talked about the two worlds, the civil and the criminal, and I want to add this third world, which is kind of the life that you're living in. And it may be that you are being victimized by someone, and maybe they haven't hit you yet, or maybe they haven't sexually assaulted you yet, or they haven't done a physical or sexual act against you yet, but they may be behaving in such a way. Maybe they haven't even threatened to kill you or to hit you yet, but they're throwing things and they're yelling a lot and they're controlling you and they're preventing you from seeing your family members or people who might counsel you that this is a bad place to be, or they're talking about just stuff that doesn't, hurting themselves, or they're telling you how fat and ugly you are and that you don't deserve anything better and I love you but nobody else will ever love you, that sort of stuff. It might be that you don't have a case that rises to a point where you can get a civil protective order or criminal charges, but it might be still that you are involved in a relationship that involves intimate partner violence. And it might be that you need to explore your options and consider whether you need to reach out and talk to someone at a hotline. And we're going to talk about some of those resources and put some of those things here. And so while it's so important, I think, that we're talking about what your legal rights are here, I think it's incredibly important too that we're talking to folks who probably aren't just lawyers listening to this. I don't really know who's listening, but people who know people who aren't lawyers, who know people who are living a life that it could be this circumstance. And we want you to have the resources to know because ideally, if you're in one of these relationships, we all want you to get out of it before you get hit, before you get physically hurt, before things turn that bad. So that's what I wanted to say. And I wanted to add to that, to know that even if you can't go to court to get help, there are places that will help you if it doesn't rise to the level that you can get court protection.
Thank you so much for adding that. The last little comment that I want to put on this discussion, kind of setting the foundation for our conversation before we move on to the next question, is just pointing out one of the things that you mentioned, Ms. Robinson-Kinney, was that domestic violence covers a broad scope of different types of violence that happen within a domestic relationship. And so I just want to be clear, again, often when we as just lay people think about domestic violence, right, that romantic violence relationship is what probably pops into our head first. And so it may be characterized as a female specific, or usually women are the victims. But for our conversation today, I want us to, keep in the forefront of our minds that this is an issue that affects children and men as well as women, and it's not just a women's issue or a women's problem.
Yeah, I think that's absolutely right. With the opioid epidemic several years ago that kind of, was coming into existence, we saw a lot of older folks of both genders. And yeah, we have seen child victims, we have seen folks in same-sex relationships. These dynamics can pop up in many different types of relationships, and as many different people as there are in the world, we have, unfortunately, victims who reflect that diversity. So it's not just one problem that is just for women or just for younger people. It's across the board.
Thank you. I'm going to go a little bit off script because I actually have a follow-up question. And listening to everyone and their examples about what could classify or qualify for an EPO, two questions popped in mind. And this is to the entire panel, so whoever wants to answer. How is emotional abuse defined? Because we're kind of mixing, at least as far as I can tell, the physical violence, the threat of physical violence, and then we've also referenced verbal abuse. So what actually is the definition of emotional abuse, and I'll stop there and then I'll ask my next question.
I'll pop in real quickly just to say that's an excellent question because the law does not define it. I think that at least my experience with my clients is that this is the thing they care the most about. This is what causes them often to seek a protective order. And then they may drop in their conversation that they've been strangled 4 times or something very serious like that. To them, though, often they prioritize getting out of the emotional abuse above any physical violence, which the law, of course, does almost the opposite in how they look at things. And so for me personally, I think that I see emotional abuse as gaslighting, making someone feel crazy, making someone feel like their feelings aren't valid, belittling, making someone feel like they're not a good mom, like they're not a good partner, different things of that nature. It can look different. But as everybody on the panel has discussed very well, there isn't a legal definition, which is why it can be difficult for people to identify what needs to happen when this is happening to them and when they're feeling this way. So I'll let some other people jump in, but that's my thought on that.
Thank you. Does anyone else have comments? Okay, so when I was listening earlier, I know that Ms. White had mentioned harassment, which again, I would think is separate and apart from emotional abuse. And that's why I'm asking the question, because it sounds like there is a gray area in the law, but I've got Mr. Tibbs saying emotional abuse alone, I think, is not sufficient under the law the way that it is currently written. However, there might be some disparity amongst the judges when counsel and their respective clients are before them asking for an EPO. Is that a fair assessment?
It's a fair assessment, because when Beth says that it's not defined, the problem I have with that is, and a lot of people on the defense side have, is that allows for the subjectivity, allows for judges to issue protective orders and domestic violence orders. You know, it's when you hear things like "you're not a good partner," or "I don't like the way you talk to me or treat me," you know, yes, that all may be reasons for why you should go and get help and go to, you know, centers and to get out of relationships. But now we're having judges issue orders which can prevent you having access to your children, which can cause consequences to your work, that could prevent if you have access not only to your children, to schools, to your work, to your home, all of those things, and getting protective orders. And that is a major problem I have with it, because it is very subjective. And I think the word is out that if you have a problem with someone, you go down to the courthouse and you take out an EPO on them. And it's not that hard to get an EPO taken out on someone. And I have had, and because I've represented people on both sides, you know, especially in family court, and I've had them say, "Oh, the clerks told me to put these," and people know the buzzwords that you need to put in, because you'll see all the factual stuff that has happened, and then at the end, "This person makes me afraid for my life." And it's like, well, where did that come from? It's like, they didn't do anything. They don't have a gun. They never possessed anything. There's been no real history of domestic violence or any history of domestic violence. But I feel afraid for my life, because they know that that is the language that if you go into court and you say that, a judge is going to probably issue a domestic violence order.
I have to. May I? I have to. I have to jump in to say that, sure, it is possible there are people who abuse this process, but there are people who are victims, and there are a lot of them. Intimate partner violence accounts for 15% of violent crime in this country. There are 10 to 12 million people per year who are physically abused by an intimate partner. That's 20 to 24 people per minute. It's 1 in 4 women and 1 in 7 men who are experiencing this. Average of 3 women per day killed in this country by an intimate partner. 20,000 phone calls per day on average to DV hotlines. 1 in 15 children is exposed to intimate partner violence in their home, and 90% of those children are eyewitnesses, and most of them are eyewitnesses to violence committed by their fathers. And the estimates are 30 to 60% of those men will go on to abuse the children in that home. This is a real issue. It's a real problem, and it is faced by so many people in this country. And I'm not doubting that there might be, Mr. Tibbs might have had a case or two, or a few even, where he thought that what happened was extreme. But what is extreme is murdering women because you want to have the control and the power over them. And we have in this community a fatality review committee, and a lot of us here are on that. And we look at those homicides when they happen, and we see patterns of intimate partner violence, and it is a real problem, and that just has to be that has to be stressed here. And I know that Mr. Tibbs is a defense attorney and does his job, and he does it well, but there are real cases of this, and there are people who are really victimized.
And see, here's the thing, and I, don't dispute that. And like I said, I've had cases with Dorislee and Erin and Beth, and like I said, think the world of them. But we're not talking about physical violence. I would agree with that. I think the question was about emotional abuse, and it's not defined in the law because it's not defined as one of the things that it was supposed to get covered by a protective order. It was supposed to be stalking, physical, I think physical abuse, and threats of abuse. But now we're talking about, physical violence and in a domestic violence setting. But I mean, my problem is that people do abuse this process, and it's not one or two cases. I see it all the time. I didn't understand it when I was a public defender because I only saw the criminal side, and the standard is a lot higher on the criminal side because you have beyond a reasonable doubt. But on the family law side, I see that people do come into court with all sorts of motives. They use protective orders to gain custody over their children so that the other side doesn't have custody. They use it as the leg up in their custody cases. They use it for child support purposes. They use it all the time to keep the kick boyfriend out of the house because they're dating someone else, and vice versa. People take out protective orders all the time, and then they dismiss them all the time because the standard is a lot lower. And there's no, if you go down to the courthouse and you lie to take out a protective order, there's no punishment to you. You're not getting prosecuted. You don't get victims. I've never seen a victim being prosecuted at the county attorney's office when I know for a fact they were lying. And someone is sitting in jail for weeks and loses their job. I would like to see if Dorislee or Erin have ever seen that, but I've never seen it in 16 years, and I think that is a problem that we see, especially in family court. I see it all the time.
I'll tell you what I see, Tibbs. I see women who are in a horror, and it's primarily women that I'm talking about specifically, as I'm talking about the cycle of violence. And you referenced the fact that people will take out emergency protective orders and then they'll end up dismissing them. And I think you are incorrectly assuming that because someone ultimately asks a judge to dismiss a protective order, it's because what they said wasn't true. And that is not the case. Dorislee just referenced our Fatality Review Committee. And one of the cases we just dealt with at our last meeting or the one before, I think there were probably, and Dorislee, correct me if I'm wrong, but I think there were 16 to 20 protective orders that were issued between this couple, primarily the woman as the petitioner taking him out against the man who was the respondent. He is the one who ultimately killed. And unfortunately, the way the cycle of violence works is that, and I'm sure everyone has heard about it. We're taught about it sort of from early on, and we're familiar with the idea. But when people are taking out protective orders, they are in a moment of crisis. They are in a moment of fear. They are often very legitimately, genuinely afraid for their lives and for their children's lives. And then the reality hits where the protective order gets served, and then he, because it's often he, has to leave the home. And then suddenly, maybe her financial support is gone. Maybe it was his family that helped provide childcare or other financial resources. And she is suddenly isolated. She's left to care for the kids. She's terrified and doesn't know what to do, except to let him back in because he has said he's sorry and he promises it won't happen again. And it won't happen for maybe a few minutes or a few weeks or a few months, but it's going to happen again. And so I would just caution you to make the assumption that because someone has sworn out a protective order and then ultimately asked the court for no unlawful contact instead of no contact, or asked the court to dismiss it, it is because she has told a lie or has violated her oath on an affidavit or made something up to punish someone in a custody battle. That happens. There are unfortunately, people who do bad things. But what we're talking about are bad things that can put people's lives at risk. And I would just, like I said, I would just caution you to avoid the incorrect assumption that a dismissal or an adjustment to a no unlawful is because the original order was based on a lie.
If I could just follow up with one question, because I think Mr. Tibbs asked this, and I don't know that there's been a direct response to it. Are there consequences for lying in an affidavit to take out an emergency protective order or a DVO order?
I mean, a person could be charged with perjury just like anyone who lies in a sworn document like that. I've not personally seen that, but I've not personally seen a case where the victim was lying in that document and should have been charged.
Yeah, it's complicated because I just think that unlike a lot of other court processes, what Erin was talking about, where what happened and they wrote about it, but then 2 weeks later they start feeling bad. Somebody has gotten to them and is talking to them. Their kids are asking to see their dad. You know, people decide to drop it or decide to amend it. And I don't know of any other court process where this happens this way. These types of, the dynamics of these relationships are different than any other court process. So I hear what Mr. Tibbs is saying, but I do have to disagree because I think that these relationships are different in that way. And that's why the law is set up the way it is. We know that they do it this way. So that's why no one gets prosecuted for, you know, taking on an EPO and then not following it through to its completion.
And like I said, I mean, I agree with what Erin is saying regarding, you know, every time a person takes out an EPO is obviously not lying, and a lot of times it is legitimate reasons that that they are under fear of being attacked. But there are a number of cases where people take out these EPOs and they have an ulterior motive. And I've represented people who have been victims of domestic violence who the previous attorney have told them to take it out because they needed it in order to better their chances in a custody battle. And one of the advantages I have now that I've worked in essentially all three phases of, you know, with this, the criminal side, the DNA docket, which is whenever an EPO is taken out on behalf of the children, which allows you to, you know, to say that the children are at risk of harm, not just the victim of domestic violence. The children are at risk because domestic violence could have occurred in the presence of the child or an earshot of the child. CPS is always called in and they investigate those cases. They show up a lot of times to your DVO, EPO hearing. And so I get to see that end of it too. And like I said, I've known victims who have said, well, I didn't really want to take this out. My attorney told me it would be better for me in my divorce or in my custody cases. And one of the problems like I said, is I have never seen in 16 years where I have proven that the person was lying and that what they said was not true. And you have evidence and you take it to the prosecutor. The best thing you get is an amendment down because they have generally a no dismissal policy in the county attorney's office, or you get your case dismissed or you have to go to trial and win the case. There's never well, this person was lying, we're going to indict her for perjury or indict this person for perjury. I've never seen that. So there are not a lot of consequences to people lying. And so it exists that there's an abuse of the process.
So Ms. Gilbert, what impact has the pandemic had on the statistics that you referred us to earlier in terms of the amount of domestic violence or intimate partner violence?
Well, let me preface this by saying that I don't think that we know fully yet what effect the pandemic has had. And the reason for that is because the most concerning thing about the COVID pandemic for those of us who do domestic violence work is that especially early on, there was forced stay-at-home orders. But even throughout, there's been a lot of social isolation and a lot of good reason to have social isolation. And as I mentioned earlier, that's a tool in the belt of a perpetrator, is that isolation. And so now we see that being socially acceptable and even mandated at times. And so as we begin to go back to our normal pre-COVID lives, I think we're going to see that there are stories of things that people have experienced during this, that victims of domestic violence have experienced that we haven't heard about yet because they haven't had the opportunity to tell. You know, it used to be that maybe they had a moment when the perpetrator went to work, or when they could go to a support group, or they could make a phone call to a hotline, or they could call their mom, or they could call the police, or they could do something. But now there's nothing that they could do because the perpetrator is there all the time with them, or the kids are there all the time and they can't talk about what was happening in front of the kids without, you know, influencing them in that way or exposing them to some of that. And so I begin by saying what we know is that we don't know everything, but the United Nations has called intimate partner violence the shadow pandemic growing amidst the COVID-19 pandemic. And we know that in some countries early on, there were significant increases in domestic violence calls. There's really limited data in the United States. So what we know is not real certain. There are some studies from early on. The American Journal of Emergency Medicine published some things saying that in the first month or so after the lockdowns happened, that there were several major big cities that had increases. In Portland, there was a 22% increase in calls. In San Antonio, an 18% increase. So there were some increases across the country. But what we know locally and statewide is that we have seen that calls to the domestic violence hotline have gone down. But again, we don't think that's because domestic violence isn't happening or isn't happening at the same rate as before. It's because there's limited opportunity to make those calls, because you can't call the domestic violence hotline when the perpetrator is right there at your shoulder or when they're checking your phone all of the time. So there's limited capacity for people who are being victimized to reach out for help. But we know at the same time, what we're seeing anecdotally is that the seriousness of the violence that is being reported, that we're hearing about, is greater than what it was pre-COVID. There's been a 70% increase in DV and IPV homicides in this state, and in Indiana, 102% increase in that time. But we also know that services for victims have been somewhat reduced during this time. Shelters have been at lower capacity because of COVID. There have been fewer in-person support groups and education groups and counseling sessions available. And telehealth is great. I love it. But it's not great if you're trying to get your therapy session with your counselor and the perpetrator is in the room next door. I mean, that's not going to work at all. So the real concern is that we just don't know the full impact yet. The impact so far is looking, you know, there are a lot of additional stressors. We've all experienced these stressors. There's lost jobs, there's kids at home all the time, there's, you know, limited financial resources, no outlets, no places to go, nothing to do. And so all of those stressors, if somebody is already prone to violence, that's just there for explosiveness and no way to get away from it for victims. So it's a very scary place for people who are in the middle of relationships involving intimate partner violence. And I think that time will tell what impact it's really had for those folks.
Thank you for that answer. I'm going to deviate also from our outline a little bit. I'm going to ask this question to the broad panel. So I want to kind of start at the beginning of the process and start to talk our way through what this might look like. If you are a person who finds themselves in one of these types of relationships that we've been talking about, where there's domestic violence, or you think you know someone who's in that situation. So it sounds to me, based on our conversation so far, that at the initial point of determining that you're in this situation, as you said, Ms. Gilbert, it's you assess your life situation and then you make a determination whether or not there's some type of court action needed. So if you're at that first point where you're realizing that you've got a problem, where's your starting point? Are there people that you should go to? You know, in other contexts as attorneys, we'd say, go get an attorney, right? So in this situation, who do you reach out to help you make that assessment of, yes, I should go forward. This is a criminal issue. This is a civil issue, or this is I just need help out of this relationship issue.
So I think there was some reference earlier, you know, we've talked about different services and support options that are available. Dorislee talked about when, you know, you started, like you said, start with that, look, what is happening in my life? Where do I need help and support? And The Center for Women and Families is obviously at the top of the list as an excellent resource for information, for support, for guidance on how to move forward. And while you figure out, because people need to make the decision for themselves where they are and what they're ready to do. It's not the same thing as a drug addiction, but I think there are a lot of analogies that could be made about, when someone's ready to seek treatment, when someone's ready to seek safety for themselves. There's some, self-reflection and some decision-making that has to be made and some planning. I mean, it's not easy to uproot your whole life, and it can be incredibly terrifying, and it can often be very dangerous. So, you start with support like the Center for Women and Families, the Mary Byron Project, the people who can give you information and help guide you. These are your options. These are how to move forward. And then at the Hall of Justice, the old courthouse, as it's colloquially known, is the Domestic Violence Intake Center. And that is the place where people can go 24 hours a day, 7 days a week to fill out the paperwork and ask a judge to issue a protective order. And I think Mr. Tibbs referenced, some of the paperwork, the affidavit. The way that it works is that, like I said, it's staffed 24 hours a day. There are folks from the court clerk's office there that actually move the paperwork through the system. But for 2/3 of the day, there's also a prosecutor, at least one prosecutor on staff, and there are victim advocates on staff from the county attorney's office. Because often there is the potential for a companion criminal case to go with this civil protective order. And so we want to make sure people know what their options are. We don't make police reports without people's permission, but we want folks to know that it's an option, and that is the first step for any criminal case to happen. It's not forced upon people, but the information is there. And so, but if folks are there to get specifically a protective order, they fill out the paperwork. They have to fill out the affidavit. And it's been interesting, a change in the process since COVID because of social distancing. Once upon a time, there would, a victim would fill out their initial paperwork, and then they would go sit down with a clerk who would type up their statement. And a lot of times the folks who are there, if they've been pushed to the moment where they're ready, especially if it's their first time filing for a protective order, they could be all kinds of scattered emotionally. They could be really stressed, really upset, and it's not really easy to focus on what would perhaps be the most relevant information. I can't tell you how many times I've had somebody come to the center, the intake center, and they'll start with, well, my ex-boyfriend called and he got really mad, and then there's like a 5-minute swirl about why he was upset about, and then he pulled out a gun and threatened to shoot me. It's like, okay, can we back up a little bit and talk about sort of the big picture of what's going on? So the clerks were able to sort of help folks narrow down what needs to go in. And now, because of COVID, everyone has to write their own affidavit. Well, not everyone has the same writing skills. Not everyone is literate and able to write. And so it can be really difficult to hone, in on what's important to go into that affidavit, because that is what the judge is going to read to determine if an emergency protective order. There's no phone call, there's no testimony. It is just the affidavit for the emergency protective order, that initial step. If the judge grants it and it gets issued and ultimately served, then you move into the family court process for the domestic violence order, the more permanent order. But that's where it all begins, is at the intake center. And there are, like I said, there are victim advocates present, prosecutors present, and I've had many cases where victim advocates from other agencies have come down. People from Kentucky Refugee Ministries have come down with folks who don't have English as a first language, or who don't have any other support system. We've had, folks from legal aid, folks from the center. The Louisville Metro Police Department has a victim services unit. They've brought people down. So there are a lot of different supports, but a lot of people don't know where to find them. And so that first phone call to the center or to the Mary Byron Project or to one of the programs that could just get you started, because it can be so overwhelming.
Can I say, too, I wanted to give the National Domestic Violence Hotline number is 1-800-799-SAFE, SAFE, and that's a great place to start. And the one thing I would add to what Erin said is, you know, sometimes when you think you have a legal issue, your first instinct is to run and hire a lawyer. And I would really caution you, if that's the circumstance you're in, if you're in a relationship involving intimate partner violence. I'm not saying you don't need a lawyer down the road, but I think if you go to a lawyer first, you've got to make sure you're going to a lawyer who understands intimate partner violence, because the number one issue is safety. And so safety planning has got to be some part of the step that you're taking. And so often you need a victim advocate, someone who's trained in those sorts of skills to help. If any of you out there are attorneys who are interested in learning more about intimate partner violence, I'm going to give my Mary Byron Project pitch here. We are doing a bunch of education about that. So look us up and sign up and be part of that. But certainly, you know, the safety planning has got to be, you know, that's what assessing where you are, and victims know their level of safety more than anyone. They can judge that better than anyone because they know the perpetrator and they know what they're capable of. And sometimes they need some questions to help them be prompted and to assess fully what that risk is. But they know what it is. And sometimes, you know, safety planning is lots of things. It's where would you go if you had to leave right now? If you could take some time to go, where would you go, and what resources would you have? And, you know, there's a whole lot involved.
Yeah, just to jump on that. So with Legal Aid Society, the Domestic Violence Intake Center hands out legal aid applications to anyone who's there who wants one, anyone at all. And then we take all of that, we evaluate whether people are financially eligible, and whether we have staff to assist them. And we provide either extended representation, like showing up to your hearing or doing your Zoom hearing with you, representing you, or in some cases, we do provide limited advice by phone, which is more of like a limited representation situation. But I will say that since the pandemic, we are getting more calls that don't go through that route sometimes, that call us, folks who call us directly. Sometimes these folks have not filed. And we're always happy to represent folks, but we're also always happy to talk to somebody about their situation, figure out if they are safe. We do have a social worker on staff who is really specially trained in safety planning, and who can assist with that, and to determine if they want a protective order, what that might look like, if criminal charges are a route they want to go down. There are a lot of, like I think some people have mentioned here, everybody's situation is different. So a protective order might not be right for some people, whereas, you know, doing this other piece might be right. Doing a safety plan might be right now, and then pursuing legal options later might be better down the road, you know, and we're happy to talk through that with folks and do that. Our office has several attorneys who work only on this issue. And then we have an excellent private bar that helps to volunteer and represent folks pro bono on these cases as well. So it doesn't really matter if you know whether you financially qualify or not. Reach out to us. We do have resources, and we're happy to figure all that out with everybody. You don't have to have it all worked out right now. You can call somebody and just talk it through with them to get some help. Like, that's what we're all here for, is to collaborate and to help people figure out what might be best for their situation.
Also, to follow up on that, if children are involved, I would say besides calling legal aid, which is a great resource, I would call CPS Hotline, because you don't always have to go to court, but the CPS Hotline is very good in that you can get a worker to come to your home. They can put together a safety plan. There is somewhat of a lag, but a lot of times in escalated cases, they get out right away and they can talk to you. One of the things I wanted to follow up earlier, since the pandemic, just from talking to a number of CPS workers, I noticed our docket in Division 7 was down last year. And then all of a sudden, as things started to ease up, our docket was out of control. And it's been that way for the last 4 months. And I think what we suspected last year is what has been the case is that as people, child abuse has gone up, because as you know, kids are not in school, they don't have access to counselors, you know, you're doing everything online. We've noticed a lot more neglect. across the board, and if there's a perpetrator, someone that's doing child abuse, they're at home with the parents and they don't have any resources and outreach. And that's one of the things we noticed. So we've noticed a tremendous increase in child abuse cases, at least in my division, and just from talking to other attorneys across the board. So that's pretty sad.
So the next question is for Ms. White. We've mentioned a few times today EPO and DVO. Can you explain for everyone what the difference between the two is?
Sure, and I welcome others to join in because while I have worked in the intake center, I've not worked in family court. I've not been in the hearing, so I will certainly defer to others who have more expertise. But as I mentioned earlier, the EPO stands for Emergency Protective Order. Kentucky also recently has IPOs, Interpersonal Protective Orders, which is really important and really great because we were talking at the very beginning about the definitions of what is domestic violence and what sort of umbrella does that capture. And for far too long in Kentucky, it was a very narrow definition that would allow for protective orders. Basically, you had to have been married or lived together or have a child together to qualify for a protective order. And as anyone who has experienced life knows that it doesn't take that sort of commitment unfortunately, for danger and violence and abuse to evolve. And so the General Assembly passed laws a few years ago that allowed for interpersonal protective orders, which expanded the definition to allow for folks who have dated but have not been married or haven't lived together, haven't had a child. It also expanded it to allow for survivors of sexual assault and stalking to be able to get protective orders. But often the parlance is the same, and the EPO is that first step that I was talking about. When you come down to the intake center and you fill out the paperwork, and judges are on call or trial commissioners are on call 24 hours a day. And so if you are at the Hall of Justice at 3 in the morning, and that's when your paperwork gets submitted, an on-call person will be reached, and they will review the affidavit and make a decision right then whether to enter the emergency protective order. And there are statutory guidelines, and they are limited to what's in the paperwork. But if within that paperwork, the statute ticks, levels can be ticked off, then most judges and commissioners would issue an emergency protective order because it is just that, an emergency. And then once that order is issued, then a date is set up in family court if it's an EPO because they fall under that old umbrella, or in district court if it's an IPO. If there are no children involved, if they haven't been married, then it goes to a different docket, an IPO. But a hearing is set, and then the process begins with trying to get the person, the petitioner is the person who files for the protective order, and the respondent is the person against whom it's being filed. And that person needs to be served because they are entitled to due process. So they have to know that this order has been issued and they are entitled to a hearing on the matter. And so once that person is served and then the matter is taken up in family court or in district court and IPO court, if a judge makes a finding, that we've talked about it in a few different ways, if a judge ultimately makes a finding that it has been domestic violence and there's a risk of it occurring again, and I think it's a preponderance of the evidence standard, then the judge can issue an order that lasts typically 3 years is the period of time, but I think there's some wiggle room depending on the parties. And then that order, that DVO, that's the domestic violence order, is the more permanent one. From a criminal aspect, because one of the charges that we prosecute we refer to as a VIPO, or a violation of an emergency protective order, that applies to DVOs and IPOs as well, but we don't typically call it a VIPO or a VDVO. We just say VIPO all the time. So that is the bigger umbrella for that potential charge. And that's where the civil and criminal overlap, because an EPO and a DVO, those are civil orders but a violation of those can result in a criminal charge. And so that's when my office steps in. And I will now defer to those with more firsthand knowledge in the process to clarify and expand.
I think you did a great job. The one thing I would chime in to say is, at a more basic level, what a protective order does or is. And so it's an order that can require someone to vacate a premises, so they can have to leave the home. It's an order that prevents the respondent or the perpetrator from being within a certain distance, whatever distance the court sets, of the person who got the order. It can award temporary custody of children. There can be other conditions such as no firearms, or conditions of, for example, for the perpetrator to get batterers intervention program treatment. There can be all sorts of different conditions. And what happens is, because that order is issued, it's entered into law enforcement databases. And for the victim survivor, if there's been a violation, or if the perpetrator is within, the distance that they're not supposed to be, they can call the police, and the police can arrest because they can access that order and see that it's a violation. So it's about safety. Again, all turns to safety. That's what we're trying to do, is help make people safe.
All right, so we've been talking a little bit about the difference between the civil process and the criminal process, and we've kind of been using those two as we know them as lawyers. So just a point of clarification, when we talk about the civil process, we're talking about the individual petitioner, me as Miss McKenna, versus the respondent as another individual, Mr. Tibbs, or somebody else, right? And when we talk about the criminal process, it's the state versus the individual, or the county. It's the government versus the individual. So just setting that foundation for a couple of things for us to talk about. So when we're talking about the DVO EPO process, that's part of the civil process, as Ms. White just explained. Ms. Robinson-Kinney, in that process, you can hire counsel. The petitioner can secure counsel, and you've explained a little bit how legal aid gets involved from the intake center, and obviously someone can call legal aid even if they don't go through the intake center, and you all take representation based on need. I understand there's also a domestic violence clinic run through the law school. Does that also go through the legal aid program? How would someone get connected with that program?
Yeah, that is an excellent question. So we collaborate very heavily with the U of L Ackerson Law Clinic. My understanding is that the majority of their cases come through us, simply because it's to kind of streamline the process. But there are sometimes folks who are have a criminal case, but they didn't happen to fill out a legal aid application when they were at the DVIC, or maybe they don't have a protective order or haven't applied for one at the stage when they might have had access to our information. So the clinic is not restricted to just legal aid referrals. They can take referrals from LMPD or from the county attorney's office. And my understanding is that they frequently do. So that's another great resource. Those are, I believe, third-year law students who have a limited license to practice. So they help people and they represent them fully, but under the supervision of a practicing attorney. And I think sometimes I've met with folks who say, well, I don't want like a law student, their case is very important to them and they don't want a practice haircut, from somebody who is not a licensed beautician yet. And I get that, but I will say that my experience has been, and I am, full disclosure, a former law clinic person, that it's a very high level of representation, a very informed level of representation. And any of the things that legal aid will do, the law clinic will do as well. They will talk to somebody who isn't sure if they want to file. They will represent someone in their hearing as long as they qualify for their services. So even though it's manifests a little differently, they do the same work that we do, and they do it really well.
I would agree with Beth on that. I'll actually, believe it or not, I was in the domestic violence unit at the Commonwealth Attorney's Office when I was in law school, and I've been up against quite a few of the law clinic people that now Judge Shelley Santry did a great job running that clinic. And those students most of us attorneys have, DVO cases, there's a long docket, and you don't get to spend as much time on those cases because a lot of times you're getting them right ahead, beforehand, whereas the law students, that's their only case. So, they're typing out their questions, they got evidence, they're coming in, they only have one case. So yeah, you're going to get a high level of representation. Plus they're going to have someone like Shelley sitting next to them or Beth supervising them.
So the other side of this is the criminal side of this. In the criminal side, the questions I have are twofold. First is how does one start a criminal process for Mr. Tibbs? And then for Ms. White, one of the things we talked about is victim advocates and kind of walking through what that looks like. So Mr. Tibbs, just very generally, if someone were interested, we talked a little bit about the criminal process, someone wants to start a criminal process, what would that look like?
Well, given that I've never worked in the DV intake center, I think the couple easy ways are the first normal way I think people would, one is you call 911 and you call the police and you say, I'm being a victim of assault, stalking, or domestic in some form of domestic violence, terroristic threat. And so you call the police. The other way I think is mentioned by Erin and Dorislee is that you would go to the DV Domestic Violence Intake Center at the Hall of Justice, and you would take out a criminal complaint. I'm assuming a warrant, a criminal complaint, and you can do that. You can also, and now I would think that's what you would do on the criminal side. I do not know any other way that you can go about taking out a charge. Like I say, from my standpoint, I always get the call once the person has been arrested and they have arraignment court in the morning or they have court in the next 10 days or so. So I would defer to them.
Well, Mr. Tibbs is exactly right. Those are the two paths. In Kentucky, domestic violence assault is what's known as a shall arrest crime. So if someone is in the midst of a domestic assault, and 911 gets called and the police respond, if both parties are there when the police respond, someone is going to get arrested. So the police who respond are put in the position of having to do some quick detective work to figure out really what happened. And sometimes it can be really difficult to figure it out. But what happens a lot of time is that when the police respond, by the time they get there, the perpetrator has fled. And so the responding officers will take a police report, assess if the victim needs EMS to get their injuries treated. If children are involved, they will often make a call to CPS, similar to what Mr. Tibbs referenced earlier. And then that report will get assigned to a domestic violence detective, because there is a specific, specially trained group of detectives that handle the domestic violence cases in Jefferson County. And so if it is a situation where someone is not arrested on site and the case needs to be investigated, then the DV detective gets assigned and they will follow up and they will, meet with the victim and determine, if maybe get medical records, figure out if there were witnesses, are there video cameras around, the general, detective work that they do in prepping a case. And then they will swear out a criminal charge, potentially, if there's enough evidence to go forward. As far as individuals wanting to swear out criminal charges at the intake center, it still usually has to start with a police report. We want to make sure that everything that can be documented and investigated is documented and investigated. I think before my time at the county attorney's office, and I think before my time even at the Commonwealth attorney's office, there was a reputation that intake was the wild, wild west, and anybody could take out criminal charges against anybody else. And that may have been the case, but it is not the case now. And so, as I stated earlier, one of the questions that the victim advocates will ask folks when they come down to file for protective orders is, have you called the police? Because for a couple of reasons. A, if they have, we want to make sure we have all of that information and make sure they know, if what's happening with that case. Because a lot of times folks don't know. If somebody gets arrested on the scene and they're at the Hall of Justice a few hours later, they have no idea what's going to happen with that criminal case. Or if a detective has to be assigned, we want to make sure we get them connected. But most of the time we will still need police involvement for them to be able to file charges. One of the very narrow exceptions would be when there's a violation of a protective order, the VPO charge I was talking about earlier. And depending on how the protective order is worded, is if it's a no contact order, there are no contact and no unlawful contact, or no contact except for, third party to discuss the children, or only text through a special app to discuss the kids and JCPS. But if it's a no contact order and the victim comes down and they have 15 recorded voicemails and 3 Instagram live videos and 2 Facebook posts where they've, made statements, and we can clearly confirm and identify the person who's calling, it's not from a Google, ghost or spoofed number, then they might be able to file. We can, probably look at the potential for filing a charge at that time. But most of the time it will start with the police report.
One thing I did want to follow up on, and Erin, or I guess Erin could probably answer this because she's in the, was at the county, is that there's this also new thing called e-warrants, which has been a new phenomenon for the last few years. And it's been a major issue, especially on the defense side, which is an electronic warrant where, and I've seen it a lot on domestic violence cases, where a person would get arrested, they get pulled over for a traffic violation and a warrant will be out for their arrest. They've never been served. They don't know anything about it. It'll be weeks, maybe months, even a year after the event. And they are arrested on something that occurred, months before. And they were like, well, I've been with this person after this event occurred, and I have no idea why I'm being charged with this. And they go to jail, and on an e-warrant, I've had a difficult time, especially with the pandemic, redocketing those warrants. Even if you redocket the warrant, the person has to go into custody that day. And I've had, people being arrested at their work, or, like I said, they get pulled over at a stoplight and for speeding or something of that nature. And then they go into jail on some event that occurred maybe 6 months before.
So I don't know how new e-warrants is. I've been with the county for 8 or 9 years now, and it's been there the whole time I've been there. When I was at the Commonwealth before, I didn't really interact with e-warrants because when the Commonwealth got cases, they'd already gone through the first few steps before they got there. So I was not as familiar with it, but Mr. Tibbs is correct there. This is the system wherein, when I was talking about the domestic violence detectives, once they get assigned a case and they complete their investigation, and either, after reviewing their evidence and often after consulting with a prosecutor, a decision is made to move forward with the charges, they file a criminal complaint, and then the on-call judge, often the same person who may be granting an emergency protective order, makes a decision as to whether that criminal complaint will be handled as a warrant or a summons. And that's because there are, especially in the cases of misdemeanor offenses, if they don't occur within the sight of the officer, or, they haven't responded and it's, both parties are still there, a detective can't just go arrest somebody for a misdemeanor that happened outside of their presence days before. They have to have an arrest warrant or have a criminal complaint to serve on them with a summons. Likewise, if there are, detectives file criminal charges that end up as e-warrants for any number of offenses, felonies and misdemeanors. And that's because they are not able to make what we refer to as a fresh arrest. They can't just go arrest them. They have to have that documentation. So that e-warrants is the name of the system wherein law enforcement can check when you get pulled over for speeding to see if there are outstanding warrants, be it for a bench warrant for a failure to appear in court, or an arrest warrant for a new criminal charge that you've not been charged with before.
Ms. White, can you explain the role of the victim advocate and what they do and how someone might get in touch with one if they needed one?
Sure. As I mentioned, we have victim advocates that are present at the Domestic Violence Intake Center. We also have victim advocates in the county attorney's office specifically. We have 5 in the SVU, just in my division. And these are folks whose entire job is to be the contact and source of information and support for survivors or victims of domestic violence. The court process is confusing and frustrating for those of us who are in it every day. And so it's incredibly much so for those who are new to it, and especially when it's such an incredibly important and scary situation that's being adjudicated. So our victim advocates, the way our system works is the first person, once the case is in the county attorney's office, the first person that the victim will hear from is a victim advocate, and they will reach out to them to let them know, okay, we've got your case. Here's what's happening. Here's when the next court date is. Here's how the process works. Tell me what happened. Tell me where you are as far as in the process. Tell me, are you safe? Do you need support? They make lots of referrals to other agencies and other support services. If it's a case where 911 was called and an arrest was made at the scene, the victim may not even know about protective orders. Maybe they were too upset, because officers will talk to folks about them at scene, but maybe they were just not in a state to take information in and retain it at the time. So they'll talk about safety planning and protective orders and what their options are. And then every time we're in court, every time a case has a court date, we will try to reach out to the prosecuting witness or the victim before and after. Because, there's often, other than that, with a fresh felony case where Mr. Tibbs talked about how they've got their first court date in 8 or 10 days, once you get past that really immediate time, cases can go on for months. And especially with COVID dockets, sometimes we have to pass a case 2 or 3 months out because there are just so many and not enough courtrooms that are functioning. And so the victim advocate will reach out, victim advocate from our office will reach out before and after all those court dates to say, what's happening? Has there been any contact? Because there's usually, in addition to the possibility of a protective order through civil or family court, there's also usually a no contact order out of criminal court. And violation of that is, again, another potential source of contempt or even other criminal charges. And so just letting them know also how the case might resolve. The prosecutor has the ultimate discretion in what kind of offers to make and how to move forward with the case. But the victim has a right to know what's going on and to be heard. It doesn't mean that we're necessarily going to be able to do everything that they want, but we have a duty to them to hear where they're coming from, to understand what their concerns are, and to make sure that we have them looped in constantly, especially with situations where someone's going to get out of custody. I'm sure people are familiar with the Vine link system, that where folks who are victims of crime can register and be alerted when someone is being released from custody, which is a wonderful system. But we also have an obligation to let folks know too. We can't just assume that someone's registered with Vine and that they'll hear that way. So if we have a court case where an attorney has made a bond reduction motion or that gets granted, or we resolve the case and that resolution leads to someone being released from custody or no longer being on HIP, home incarceration, we have an obligation to make sure the prosecuting witness knows, and we have to do everything we can to keep them informed so that, again, going back to that theme of safety and protection, so they know what's happening and they can plan accordingly. You asked what people could do if they need a victim advocate. I will go back to what some of the agencies we talked about before. The center provides advocacy, legal aid provides advocacy, Mary Byron Project. Additionally, I think I mentioned earlier, Louisville Metro Police has a victim services unit that has really been wonderful. There's a significant focus on violent crimes and major crimes, but for a case, from the time someone's arrested to the time that the case would be in my division and a victim advocate would be reaching out, it could be several days. just because of the way the court system works. If someone gets arrested on a Friday night, my division's not gonna have a case until Monday or Tuesday. And so that LMPD Victim Services Unit is so much faster to reach out to folks. And it's so nice for there to be a continuum of contact, because if it's a felony case, it's going to be at the county attorney's office for a little while, and then it's going to be at the Commonwealth attorney's office, and the whole system starts over again. And it can be very frustrating for victims. Even though there are wonderful victim advocates at both offices, having to start over can often be a re-victimization for someone. Like, tell me again what happened to you that you've already had to tell how many people that you don't want to talk about anymore. So the victim services unit with LMPD can be really key in helping folks who are having trouble with communicating, having that steady contact throughout.
Thank you, Erin. The next question is for Ms. Gilbert. If you could tell the audience about Vine. We heard Erin mention it. What is it, what it does, and how can people sign up?
Sure. I am happy to talk about Vine. So Vine stands for Victim Information and Notification Every Day. And Vine was created, let's see, it's been over 25 years ago. It was created in direct response to Mary Byron's murder. And so at the Mary Byron Project, we have a real connection to Vine. It is the most widely used victim notification technology in the country. It's used in 48 states and thousands of correctional facilities. But what it does is it's a system that allows someone to go online. You go to vinelink.com and you register, and you can register to know when someone's status in custody changes. So if their bail is posted and they get out, you can register for court dates. If you have applied for a protective order and you've gotten an EPO, you can register to find out, to know when the respondent is served with that. And again, that's an important step in keeping someone safe. If you know when someone's released from custody, Mary Byron didn't know when her offender was released from custody, and he armed himself with a gun and stalked her to work and killed her on her 21st birthday. And Vine was created to stop those kinds of things. And we believe that it has over the 20 plus years that it's been in existence, because it informs people, it gives them information, and you can get information in multiple languages. There's apps, there's emails, you can get phone calls, there's all kinds of different ways. It's really vital technology for someone who is trying to keep safe and to know what's going on with the case, or to know when a perpetrator might be angered because they're served with the EPO papers or something like that. Just a really critical resource.
Thank you so much for sharing about that program. I want to remind our Facebook audience, I apologize if we did not say this earlier, if you leave a question in the comments, we can answer those. We're getting towards the end of our time. We have received one question from the audience that I want to ask, and then I want to kind of expound on a little bit. The question from the audience is, how does each party to domestic violence cases participate in court proceedings during the COVID pandemic? Because we're obviously, those of us who are lawyers know we're doing Zoom court these days, or phone conference court. So what does that look like? And related to that, I recall seeing on Facebook one of these viral situations where a domestic violence proceeding was happening, and the court was able to identify that the perpetrator was actually in the same room or right next door to the victim, and was essentially, trying to coerce the victim during the proceeding. They were able to get the police there. I don't know if you all have seen that video, or if you all have seen experiences of that here in Jefferson County, and how Jefferson County attorneys in this space are kind of addressing those concerns.
I can say that, as far as Jefferson Family Court goes, they have done an absolutely phenomenal job at making everything remote. The way that it works is when people fill out their EPO petition, they get a piece of paper that has a name a number and an email for the case specialist for that division. They contact them, or in many cases, the case specialists reach out, take the initiative and reach out to folks. And they kind of figure out, like, can you participate by phone? Can you participate by Zoom? They got feedback from the lawyers that they wanted to have everybody on the same platform. So they did that. And they streamlined it in such a way that I think many people have been able to participate very easily remotely. And I do get some feedback from some of our clients that they like this better, because it can be scary to be in a courtroom with this person who's your partner, who you're confronting about their behavior in a very public way. And it's actually been a little bit easier to have that conversation in a remote environment. So many of the folks in Jefferson County are doing this remotely through Zoom. And I just have to take my hats off to the Jefferson County Family Court System, because they absolutely coordinated a very cogent response to that pretty quickly. Because even when all these other different dockets shut down, emergency dockets like the DNA docket, like the domestic violence docket, never shut down. And so they had to adapt pretty quickly, and they were able to do that really well in a way where people are able to participate. And they do take into account interpreters and connecting interpreters through Zoom, folks who maybe don't have good internet access, doing it by phone. There are a lot of options available to folks during the pandemic. I've been really pleased with that myself.
Yeah, I would agree with Beth on that completely. At family court, one of the problems with the DVO docket pre-pandemic, and it's been the case, is that it's kind of like a cattle call. So you always have to have a number of sheriffs out there, because there was so many fights that always occurred at the DVO docket. I've seen, victims of domestic violence be intimidated by the respondent, and the respondent will bring either new girlfriend, and even though the respondent can't talk to the victim, the girlfriend will go over there and say, you need to dismiss this. And so at least with Zoom, person is in their home, they have, they don't have to, be in the conference room. They don't have to be in the courtroom. So I think it works really well. And I have forgotten what it's like to be in a courtroom. I mean, Zoom has been great. I mean, we're able to share the screen so I can introduce exhibits just like I would in the courtroom. So I think it works out really well. Another thing is that if a DVO is issued, a victim, a person that has a DVO issued against them, the victim of that domestic violence order is not forced to participate in a mediation. So if it is a divorce or a custody battle, because of a DVO, they don't have to participate in mediation. And most of these cases need to be mediated because each of these judges in family court have like 2,000 cases. And so it causes a delay in trying to get things resolved, such as your divorce or trying to get custody. Well, since we've been doing Zoom, victims are feeling a lot more confident in going into mediations, because you're going to be in separate screens. You can be in separate rooms. You can stay in your home. You don't have to go to the same facility as the other person. So Zoom I think has been very good, I would believe, for people that have DVOs.
So it sounds like you all have not had any concerns of coercion of victims because they are at home. In fact, it's actually been better for victims in most instances.
That's been my experience. I did see the video that you're referring to, and that is a very scary situation. I don't know that I've had any that mirrored that, or where I suspected that somebody else was at that location. That is a risk. For sure. And I think that in that video, if I recall correctly, the prosecutor mentions different things that she was noticing, like the person was like looking off screen a lot, like at somebody else, or something like that. And I hadn't necessarily noticed that in any of my cases, but that is a risk that I suppose that could happen.
We have a criminal court, which the case that I think that went viral, I think was a criminal matter. One of the things that a lot of the judges do that I really appreciate, that I know can probably frustrate some people, is they ask, once your case is being called, they ask everybody to have their camera on, at least for a little bit. Now, obviously, not everyone has smartphone or laptop capability, and so the Zoom calls you can get into the Zoom court through a telephone line, so not everyone has video. But for the folks who do, most of the judges say, listen, I need you to turn your camera on, because they just want to kind of, let's see everything that's going on and get, a real picture of what's happening. As far as that specific circumstances, like Beth, I have not had any personally. I think that we have, several of my coworkers and I have suspected at times, but there's not been enough there that we could ask the judge, to order anyone to speak up or show what's going on. And honestly, a lot of the intimidation and contact is that we deal with starts before that hearing. We check jail phone calls for just that reason, because from the moment someone's locked up, they can start making phone calls pretty quickly, and those are all recorded. And even though they're told throughout the pendency of the phone call that it's, every time that it's being recorded, folks don't always make very good decisions. And I mean, I had a case recently that was the first phone call that the perpetrator made to the victim. She answered, and she was at the hospital. You can hear the doctors at the, it was the end of the visit. They were giving her the medication, telling her how to care for herself. And these are the injuries that he had just caused. And then that first call, she answered, but she was saying, you did this. I don't want to talk to you. I don't appreciate it. And then the calls continued over the next few days. And it was almost like a study in the cycle and the impact that, perpetrators can have on their victims, on that intimidation, because they moved through where she was clear and adamant that she wanted nothing to do with him, and he did this himself. He put himself in jail. It was not her fault. He put his hands on her, and that's why he was in jail. And then within, a week, by the time the first court case came around, she was logged on to Zoom to, testify on his behalf if the court had let. And a lot of the judges, if we're at an early stage in a proceeding, they don't want to put folks in that position if they don't have to. So they will, if victims want to be heard by the judge to say something, but they're not going to often put them under oath and have them testify, because it's the judges, most of them understand the dynamics and the risks involved there as well.
So we have another great question from our audience, and it is, what do the parents of minors do if they suspect domestic violence in their child's relationship? Is the process the same?
One of the other expansions that we got through IPOs, because it changed the definition of who could apply for protective orders, teenagers can be both the petitioner and the respondent on a protective order. Often adults have to be involved, and so it's helpful if a teen has the support of a parent to help them, to be an adult witness for the affidavit. But when that law went into place, I was actually in juvenile court. I started at the county attorney's office in juvenile court, handling all of the domestic violence and sexual assault cases in juvenile court. And I was there when the law changed, and there was a great group of folks who worked together to figure out how on earth do we handle IPOs with teenagers. And JCPS was involved, and because there were thoughts of, well, what do we do if they go to the same school and a judge issues a 500-foot radius? And so JCPS is in the loop immediately if a teenager, picks up domestic violence criminal charges, or if there's a protective order, and JCPS will transfer a child who is the respondent, who is the perpetrator, to a different school during the pendency of that protective order. So there are supports in place, but it is very helpful if there's a parent or an adult who can help get that teen started, because there are not a lot of teens who have the wherewithal or the the confidence, if they're in that situation, to seek the help themselves. So looking for all those warning signs. Dorislee talked about a lot of them earlier. It's the same with teens as it is with adults, being isolated and cutting off relationships outside of that intimate partner relationship, the sadness, the moodiness, the unexplained crying jags, being very secretive about things. If that can mean a lot of things with teenagers, that can mean a lot of things with with adults, but educating yourself and not being afraid to ask others for help as the adult. And then the most important thing I think anybody can do when wanting to help a loved one, be it a juvenile or an adult who's in a dangerous situation, is letting them know that you are there for them and you're listening to them, and letting them kind of guide, let them tell you the best way to communicate, because maybe they don't want to text because someone checks their phone all the time, but they can message you on Facebook or Insta because that person doesn't have the password to that, or letting the person who's in the situation kind of guide, and respecting their fears, because like Dorislee said, they are in the best position to judge their own safety and their own risks, and trusting them to help to accept your help in the safest way they can.
Well, thank you all again so much for your time tonight. We are out of time. I think we could talk about so many more issues, and we have this problem every time we do one of these. We always run out of time. We even made it longer and we still run out of time. So thank you all so much again on behalf of the LBA Public Service Committee. And I know Michelle feels the same way. We really appreciate your time. Michelle, any parting thoughts?
It would help if I wasn't on mute. No, I don't have anything else to add. Just Charles W. Anderson Junior Bar Association thanks each and every one of you for your time. I think today was tremendous in terms of the information that you shared. Ms. Gilbert, if you want to give the contact information for your organization again, just so everybody has it, I think that that's always good. And Mr. Tibbs, if you want to let the audience know how to contact you as well, I think just as many resources as we can remind our audience of before we log off, I think it would be fantastic. Thank you.
You can find the Mary Byron Project at www.marybyronproject.org, or you can email us at info@marybyronproject.org. And those are the best ways, really, to get in touch with us.
Thank you, everyone. Like I said, this is a great panel. I think the role of all three of the attorneys that are on here that was speaking. The easiest way to get a hold of me is Tibbs Law at my website is www.tibbslaw.com, and Tibbs Law at tibbslaw.com is my email address. And the easiest way to find me on the phone is 654-8422, which is also TIBB. So it helps to be the only Krsna Tibbs on Google. Pretty easy to find me.
And Ms. Robinson-Kinney for legal aid, if someone wants to get in touch with legal aid.
Yes, so my email is brobinson-kinney@laslou.org, laslou.org. But if that is too much to remember, which it often is, feel free to go to our website, which is yourlegalaid.org. We are the Legal Aid Society of Louisville, and we do serve the 14, I believe, surrounding counties as well. And just keep in mind, we were talking about protective orders, but we do divorces. We have a custody hotline that serves the entire state of Kentucky, where you can call and ask some custody questions. We do expungements, housing and eviction work, government benefits, and I'm leaving off many, many, many areas of civil legal services that we provide. It is common for folks to have more than one civil legal issue, and if they're living in poverty. And chances are that if you call us, we can help you with one of them, if not more. So feel free to reach out. I think the best way is the website. And we do have an intake phone line. Our intake folks, although they are working from home, are answering the phone all day during business hours. And thank you for having me very much. Thank you, everyone.
Thanks, everyone. Have a great night.